Does the bankruptcy judge or does the bankruptcy court make a distinction between a divisional merger bankruptcy in good faith and one in bad faith?
Yes, I think a bankruptcy judge would. I think they would look at the bad co, to use the term that we've adopted from Judge Fitzgerald. They'd look at bad co and they'd ask the question, is that an entity that is in bankruptcy for a proper bankruptcy purpose? And if you set up a bad co that had real assets in it and it had the liabilities as well, you might say yes, that's a proper purpose for that for that entity. But the judge looks at what went on in the particular divisional merger and makes a decision.
Hey everyone, welcome back. Today we're diving into a Senate Judiciary Committee exchange. Senator John Kennedy questions 3 legal minds about the Texas two-step. A company splits assets and liabilities, then bankrupts the liability-laden entity. Sound shady? Kennedy wants answers.
When a divisional merger is done, and then there's a bankruptcy, and you have 2 companies, I'll use the terms rich co and poor co, as opposed to good and bad. Does the bankruptcy, I assume that counsel for the creditors is raising fresh hell and saying this divisional merger was in bad faith, and it was only done to avoid liabilities. Assume that's one of the allegations. Does the bankruptcy judge then hold a hearing and look to Porco and its present and prior management and say, tell me why you did this divisional merger? And if they say to avoid our liabilities, does the bankruptcy judge then have authority to say, no, get out of my courtroom?
The answer to that would be yes.
Let's break it down. Kennedy asks, how does a bankruptcy judge decide if a company's filing is in good faith or bad faith? Professor David Skeel says, if the new bad company has a legitimate bankruptcy purpose, a judge might allow it. But if it was set up just to dodge responsibility, that's when the red flags go up. Kennedy brings up rich co and poor co to make it simple. The answer, according to Skeel, yes.
Let me ask Mr. Zumbro. It seems to me that the issue is, do we have a prophylactic rule passed by Congress that says you can't do a divisional merger and then a bankruptcy? Or do we rely on the bankruptcy judge to decide when a divisional merger is in good faith and bad faith? Bad faith meaning to avoid your creditors.
Senator, I think that's right. I think the bankruptcy courts are in much better position to evaluate those issues than Congress. I don't think a law that flatly prohibits a bankruptcy filing after a divisional merger is appropriate.
Kennedy keeps digging. Do we need Congress to ban this tactic, or can judges handle it case by case? Zumbro says judges can handle it. He did a divisional merger recently, totally legal. But Kennedy isn't so sure. Jonathan Maclay drops a bombshell. In the Fourth Circuit, even bad faith isn't enough to dismiss a bankruptcy case. A judge can find bad faith and still let the bankruptcy move forward. That's not just a gray area. That's a loophole big enough to drive a bankrupt truck through.
I think the courts can make these determinations on a case-by-case basis.
I understand. Could I ask, Mr. Chairman, for 30 more seconds, could you weigh in on that, Mr. Maclay?
Absolutely. First of all, what Mr. Skeel said, what Professor Skeel said, is not accurate in the Fourth Circuit. In the Fourth Circuit, where these bankruptcies are all originally filed, bad faith is not enough to dismiss the bankruptcy. A judge could find it's in complete bad faith, it's a scheme, it's a fraud, but yet if the defendant, if the debtor can argue there's a reasonable likelihood of a successful reorganization, a standard which is almost impossible to meet, then the bankruptcy has to stay. So dismissal is not an adequate remedy, even for bad faith under the law of the Fourth Circuit, where they of course file.
Why it matters and the bigger picture. Let's pause here. If you're finding this breakdown helpful, hit that subscribe button and turn on notifications. Now back to the big picture. Are massive corporations exploiting this tactic to avoid responsibility, especially in lawsuits, consumer claims, or victims of wrongdoing? Do we need a universal legal fix from Congress? Or can we rely on judges bound by precedent? Maclay argues we need a federal rule. He warns that letting judges sort it out case by case isn't cutting it. The final word. Before wrapping up, Kennedy makes one last move. He submits expert statements from Professors Anthony Casey and Parikh. This isn't just legal hair splitting, it's about corporate responsibility and the integrity of our bankruptcy system. Conclusion: should Congress step in with a clear rule, or trust bankruptcy judges to keep things fair? Let me know in the comments, like, subscribe, and share. Thanks for watching. See you in the next one.